Aloha, it's Professor Wes Porter. This is Article 4, Federal Rules of Evidence, specifically the policy rules, Rules 407 to 411. This is Rule 407, one of my favorite subsequent remedial measures. And the important parts to think about with these policy rules, they're really easy to spot. They handle very discrete things, and you can see how they could overcome relevancy and have trouble maybe with the balancing test under 403. So there's specific reasons why we wanted to encourage certain behavior out in town and not lead to odd results out in town, out in the world. So we needed a policy rule to say what can and can't be introduced in a trial. I want you to think about and look at, this is one of the first times we're talking about this, the foundational requirements of a rule. This is a rule of evidence. That's a rule of exclusion. That means the opponent is looking at Rule 407, subsequent remedial measures. They're patrolling the evidence and saying, when am I going to throw this flag? When am I going to object under 407? And really, they're going to object when there's 1, 2, 3 elements met. And we think about elements when we think about elements of a crime, elements of a claim in the civil side, but these are really elements of a rule, elements of an objection. And what we do is we call that foundation, right? This is the foundation for the rule. And you'll see later on under other rules, there'll be foundational elements of an exception to a rule. So keeping track of what side we're on and who owns the foundation is important. Here, the opponent owns the foundation. The rule says when measures are taken that would have been taken earlier, would have made it less likely to occur, then those measures are not admissible to prove essentially that they did it, negligent, culpable, that it's defective, whatever. So think about it. That's 3 foundational elements to this objection for the opponent. 1, there has to be a measure. We'll talk about what that is. The measure had to be taken, if it had been taken before the accident, before whatever happened in this civil trial, before the accident, before the event, that it would have made it less likely to occur. So it's a measure that would have made a difference had they done it before. And just like we see in all of these policy rules, what is the proponent trying to do? The bad purpose in this rule is you can't introduce that measure that if they took it before would have made it less likely to occur if you're doing it to show negligence. So an easy way to think about this, person going down a hotel steps, it's got a thing on the little edge of the step, the metal edge of the step is undone, it's sticking up, they trip, they fall down, they get injured, they sue the hotel. They're all the way at trial. Well, obviously, after that day, after that event, the hotel went, and we want them to go fix that step, go fix that metal ledge on the edge of the step. And they do. So they take a measure, right? They fix something, they enact a new policy, they do something that had they done it before the accident, had they fixed that step before the accident, nailed down that metal strip at the end of the step before the accident, it would have made it less likely to occur. And we can't introduce that for the purpose of showing that this hotel was negligent, that they were culpable, that they did something wrong. Just think about it. Otherwise, everyone, all these defendants would essentially just leave everything in disrepair, just leave everything the way it is until the whole lawsuit's over for years. We can't have that. So the foundational requirements measure, did they do something? And it has to be that the actual party did something here. So the hotel owner, who was the defendant in the lawsuit, took a measure, did something in the lawsuit. And if they had taken it earlier, it would make it less likely to occur. And now the proponent at trial, that plaintiff at trial, the person who fell, is trying to offer it for this bad purpose to show negligent, culpable conduct. So the defendant hotel, their lawyer is sitting in opposition, sitting ready to object, sitting as the opponent. And when they get into this fixing the stair after the fact evidence, objection, it's irrelevant. Probably going to lose that one because we know about that rule. Objection 407, subsequent remedial measures, and maybe objection 403, this is unfairly prejudicial, right? The jury just makes too much of fixing the step after as some type of admission that they have done something wrong, and there could be all sorts of other things going on in the case. So taking this measure, if they did it before the accident, before the event, it would have made it less likely to occur for the bad purpose. That's what the opponent is saying. That's what they're going after in this case. Well, just like everything else, we make our way over to sidebar. Proponent has 2 hands up in the air and saying, no. I may be putting on some evidence of this measure that was taken, this repair of the steps, but I didn't do it for the bad purpose. I'm not trying to show negligence or culpability or show that the product was defective. I'm doing it for some other purpose, some other purpose that's allowed under the rule. So just like all of these policy rules, some have just the bad purpose set out in the rule and any other purpose we can get in. Others do it just this way. A paragraph of this is the bad purpose. This is the purpose for the opponent, the one who's objecting, one of the foundational elements of the objection. The second paragraph here, but the court may admit this evidence for another purpose, is for the proponent. The proponent goes over responding to this objection and says, no, 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 not bad purpose. I'm offering it to show if disputed ownership or control or feasibility, right? And we talked about this before. Maybe it's disputed in the case whether the hotel even owns the staircase and even owns that step. Well, the fact that they fixed it after the fact can be used to prove ownership, not negligence. And you can imagine how a 105 limiting instruction could come into that, because the opponent would say, objection, 407, subsequent remedial measures. They took a measure. If they did it before the event, it would have made it less likely to occur. And Your Honor, trust me, this proponent is doing it for the bad purpose, proving negligence, proving culpability. A proponent says, my turn, Judge. Your Honor, I am putting on evidence of them repairing the stair after the fact, but I'm not doing it for the bad purpose in the rule. I'm doing it to show ownership only. And this can be cleared up with a 105 limiting instruction that the jury should consider it for ownership, an acceptable purpose in the rule, but not to show that they did anything wrong, the defendant was negligent or culpable. So it's a classic good purpose, bad purpose type of rule. It also has the 1, 2, 3 of foundational requirements of the objection that are owned by the opponent. Subsequent remedial measures. Don't get tripped up. What can be a subsequent remedial measure? Can be anything. The idea that a company doesn't have a really good sexual harassment policy. There's a lawsuit, and then after the fact, they put in a really good policy and they get their lawyers together and come up with a better policy and maybe even training. Well, all those things, right? Those are measures. That's something that if they did that before this incident, maybe what happened in the event would not have taken place. So it's a subsequent remedial measure. Why is the proponent trying to do it? Are they trying to offer it to show that they were wrong in this case, that they were negligent in this case, that they were discriminatory in this case? Then it's going to be out. Those type of subsequent remedial measures are out. But maybe they're doing it for some other reason. Maybe they're doing it for impeachment. You see, impeachment is a unique one to be under the good purposes for the proponent. But imagine on direct examination, an HR director in the company said something to the effect of, we've never had any problems with our policies and we've never had to change any of our policies. We have the best policies and there's no reason to ever change them or revisit them. Well, now I'm the proponent. I can introduce this evidence of the new policy and the changed policy about sexual harassment, not for the purpose of showing negligence or culpable conduct as prohibited by Rule 407, but instead, I'm going to say I'm offering it for impeachment. It goes to the credibility of the HR director of the company. That's why I'm offering it. And again, we can separate out those good purposes versus bad purposes with a limiting instruction under Rule 105.